Nobody saw this coming. Not the legal analysts, not the political strategists, not even the people inside Trump's own inner circle who thought they knew exactly how this was going to play out. One sealed envelope, one audio recording, 11 minutes and 43 seconds of audio that Pam Bondi, the woman Donald Trump personally trusted with the most sensitive legal matters in his orbit, handed directly to a federal court. And the moment that tape entered the official record, everything changed. Not gradually, not over weeks of procedural maneuvering. In a single afternoon, in a single courtroom, with a single act that nobody on Trump's side anticipated. Because here's what you need to understand before anything else. Pam Bondi wasn't just a political ally. She wasn't just a former attorney general who had backed Trump through every political storm. She was the person trusted with access, with files, with communications that were never supposed to leave a very small circle. The kind of person you bring inside the tent precisely because you believe they will never, under any circumstances, let anything out of it. That calculation just collapsed in the most public and consequential way possible. And Trump's response, he didn't stay quiet. He didn't let his lawyers issue a measured statement. He went further than anyone expected. Sources close to the situation say he is demanding Bondi face criminal consequences. Not a lawsuit, not a civil action. Bars. An actual criminal referral for what he is calling an act of deliberate betrayal that crossed every legal and ethical line that should have protected that recording from ever reaching a courtroom. The fury inside Mar-a-Lago after this broke is being described as something nobody has seen before, even by people who have watched Trump operate through years of political and legal chaos. So what is on that tape? That's the question that every legal analyst, every political observer, and every journalist with any proximity to this story is trying to answer right now. The recording involves Melania Trump. That much has been confirmed through multiple channels. 11 minutes and 43 seconds of audio in which the First Lady's voice is clearly identifiable, discussing matters that her husband's legal team had worked very deliberately to keep sealed, to keep private, to keep completely outside the evidentiary record of any proceeding. The recording didn't surface from nowhere. This tape existed. It had been known to exist by a small number of people inside Trump's legal and political apparatus for some time. The question was never whether it existed. The question was who held it, who controlled it, and whether it would ever be introduced into any official proceeding. Bondi's decision to release it, and it was a decision made deliberately with legal counsel through proper channels, represents something that goes far beyond a simple leak. This was a formal submission, a documented intentional act of introducing specific evidence into an active federal proceeding. That distinction matters enormously, because a leak can be challenged, dismissed, attacked as politically motivated noise that a court doesn't have to take seriously. A formal submission to a federal court is part of the permanent record. It goes through authentication. It carries the weight of an officer of the court presenting evidence. And Pam Bondi, whatever else she is a former attorney general who knows exactly what she is doing when she walks something into a federal courthouse and hands it to a judge. She understood what this would mean. She did it anyway. Here's what the 11 minutes reportedly contain. According to legal observers briefed on the tape's general substance, not its full contents, which remain under seal, the recording captures Melania discussing the internal legal strategy surrounding one of the most sensitive aspects of the Trump organization's financial exposure. Specifically, what she knew, when she knew it. And critically, the framing she was told to use if she was ever compelled to speak under oath about what she had observed during specific periods when key financial decisions were being made. This isn't background conversation, this is substantive. And it directly intersects with questions that prosecutors have been trying to answer for years. Now, here is where it gets truly complicated. Melania Trump has, throughout every phase of her husband's legal battles, maintained a protected distance from the proceedings. She has not testified. She has not been subpoenaed in any major proceeding. Her name has appeared in the margins of various filings, but never at the center. Part of that protection has been built on the careful argument that she had limited substantive knowledge of the business decisions at issue, that she was present in the household but not in the boardroom. that her role was personal, not operational, and therefore her testimony would carry no meaningful evidentiary weight. That argument just became significantly harder to make. Because if the tape contains what sources are indicating, a candid, detailed, unprompted discussion of what she actually understood about the financial landscape of the Trump organization during the period prosecutors care most about, then the careful wall built around her testimony starts to develop cracks that are going to be very difficult to repair. She wasn't just present, she understood, and in 11 minutes and 43 seconds of audio, she apparently explained exactly how much she understood to someone she trusted in a conversation she clearly never expected to be heard by a federal judge. The legal mechanics of what happens next are critically important and almost completely absent from most coverage of this story. The tape has been submitted. It is now in the possession of the court. What the court does with it depends on a series of procedural steps that Trump's legal team is going to fight at every stage. They will challenge authentication. They will argue privilege. They will file emergency motions claiming that the recording was obtained and transmitted in violation of specific legal protections that should have prevented it from ever being used in any proceeding. These are not frivolous arguments. Some of them have real legal merit. But here's the problem with that strategy. Bondi is not an outsider. She is not a disgruntled former employee who grabbed a recording and went to the press. She is a former United States Attorney General with deep knowledge of evidentiary procedure, with her own sophisticated legal counsel, and with a documented legal basis for why she believed the recording could properly be introduced into this proceeding. She prepared for the challenge, she expected the emergency motions, and she submitted the tape anyway, which means she believes she has legal ground to stand on when those challenges come. That confidence should terrify Trump's legal team far more than the existence of the tape itself. Because if Bondi is right, if there is a legitimate legal pathway through which this recording enters the official record and is authenticated and considered by the court, then what is on that tape stops being a political controversy and becomes a piece of evidence in a federal proceeding. And federal proceedings don't care about political narratives. They don't care about loyalty. They care about what the evidence shows and what it proves. Let's talk about why Trump is calling for criminal consequences. When your instinct is to go after the person who released evidence rather than to address the evidence itself, it suggests you believe the evidence is real, it's accurate, and attacking it directly is not a viable strategy. The demand for Bondi to face criminal consequences is framed publicly as a betrayal of legal privilege, and there are serious legal scholars who think that framing has some merit. If Bondi received this recording in a context that created any form of privileged relationship, her disclosure could carry legal consequences. But here's what that argument misses. Privilege is not absolute. There are specific, well-established exceptions to privilege protections, including the crime fraud exception, which allows evidence to be introduced when it shows that privileged communications were used in furtherance of a crime or fraud. If Bondi's legal team is arguing that exception applies here, and sources familiar with her legal strategy suggest that is exactly what they are arguing, then the privilege challenge becomes not just difficult to win, but potentially counterproductive. Because litigating the crime fraud exception in open court means putting before a judge the very question of whether the communications being protected were themselves connected to fraudulent conduct. That is not a door Trump's legal team wants opened any wider than it already is. Melania's position in all of this is unlike anything we have seen in the long and complicated history of this family's legal entanglements. She has stayed silent through all of it. Through the criminal trials, through the civil fraud case, through the appeals and the rulings and the political warfare that has surrounded every stage of this saga, she has been the one figure who managed to remain almost entirely outside the blast radius. Now her voice is in a federal courthouse, on tape, in a recording that a former attorney general she trusted decided was important enough to submit formally to a court despite knowing exactly what it would unleash. There is something else happening beneath the surface of this story that has not been said directly, but that everyone who has followed this case for years can feel. The circle is getting smaller. The people who were once inside it, trusted with access to the most sensitive information, given responsibilities that place them near the center of decisions now under legal scrutiny, those people are making choices about what they know, about what they hold, about what they decide to do with it. Bondi's decision is not happening in isolation. It is happening in a context where multiple people who once stood close to the center of this operation are quietly recalibrating their own positions. That recalibration is what should keep people watching this story more than any single dramatic headline. Because what one person does sends a signal to everyone else in a similar position. Everyone who holds something, everyone who was in the room when decisions were made, everyone who signed documents, sent emails, attended meetings where the substance of what is now being litigated was discussed openly, without the awareness that a federal court would someday be reconstructing exactly what was said and who knew what. Bondi's submission of this tape is not just a legal act, it is a signal, and signals get received by the people they are meant for. The tape is in the courthouse. Melania's voice is on the record. Trump is demanding consequences for the person who put it there, and the court is deciding what happens next. This is not a story that is settling, it is a story that is accelerating. And when you understand what is actually at stake in those 11 minutes and 43 seconds of audio, you will understand why nothing about what comes next is going to be quiet, contained, or simple. The recording exists, the court has it, and everyone who matters in this case is now figuring out what that means for them. Stay close, because what comes out of that courthouse in the next 30 days is going to change this story in ways that nobody is fully prepared for yet, not even the people who started it.